EBS analyst Oshoria Omije. Good morning to you. Welcome to Daybreak.
Good morning, Ma. Good morning, Edo people. It's nice to be here again.
All right, to the topic for discussion, the unending pre-trial detention. What's your take? We see a lot of persons behind bars in prisons for years that might even be longer than the original sentence that they would have done if they were actually convicted. So,
okay, thank you very much for that question. It's painful, and it's anti-humanitarian seeing people go through such hurdles. According to the words of Tunji Braithwaite, he said that justice delayed is justice denied. And the funny part is that it has so many persons have been quiet about all of this. According to statistics, Nigerian Correctional Services and Nigerian Bureau of Statistics claim that over 65% of Nigerian inmates are awaiting trial out of the over 80,000 inmates that are present in our Nigerian prisons. And the funny part is that we have capacity for inmates for just 50,000 plus. And if you look at it, you discover that it's against humanitarian, and it's really painful that we are at this situation. I'm very happy for this topic because this has really made a lot of people to suffer. Many of these inmates even die in prison. So right. It's a bad one.
Okay.
It's a bad one.
So let's hear from the legal practitioner. Good morning to you, Right Honorable Samson Osage.
It's been quite challenging connecting with you this morning. Good morning. Nice to be with you this morning.
Yes, nice to finally have you join us on the show this morning.
Yeah, thank you very much.
Unending pre-trial detention in Nigeria. We have seen cases. We have them with us right now, and it's plaguing us seriously. Congesting our prisons. People serving pre-trial terms before they are actually convicted, and some have served terms that they would have actually, served if they were, their cases were judged and convicted. Why so?
Well, first and foremost, let me say that the incidence of endless pre-trial detention in Nigeria is not a problem with our legal system simplicity. What I mean is that the laws that regulate the administration of criminal justice, both the substantive and the procedural law, are well in place. The challenge we have is the operators who are expected to follow the dictates of the law and comply in such a way that the society, the victims of crimes, and of course the defendants as well are protected. First, let me start from the note that the Administration of Criminal Justice Act of 2015, which was passed by the National Assembly and subsequently domesticated by the various states in the Federation, was enacted to ensure speedy dispensation of trial. That is the primary purpose of the administration of criminal justice,
yes,
in the country as of today. And it contains provisions under which suspects who are alleged to have committed an offense are to be dealt with in a manner that is consistent with the law and also respecting their rights and ensuring that there is justice. So the primary purpose of the administration of criminal justice is to ensure speedy dispensation of trial, strengthen administration of criminal justice institutions, protect the rights of the citizens, in other words, protect the defendants and protect the victims of crimes.
So
now,
what's
that is the purpose?
Yes, so what's the bottleneck?
What is now the challenge? What is now the challenge that our prisons have become so congested because there are pre-trial cases that are keeping suspects in detention longer than necessary. And it is a multi-dimensional challenge. I mean, in other words, we can situate the problem within the context of the various actors within the justice system.
Okay.
Now, where does this start from? It starts with the arrest of a suspect. Normally, when the suspect is arrested by the police or any security agencies, they are supposed to, within the shortest possible time, conduct their investigation and charge the person to court. That is what the Constitution says, particularly, particularly Section 35, talking about personal liberty. Now, charge them to court within 24 hours and at most within 48 hours. Now, but the administration of criminal justice recognizes the fact that there may be situations where, because of the nature of the offense, because of the circumstances of the matter concerned, it may not be possible to conclude the investigation, within such a time. The administration of criminal justice requires that a report, an application for request for remand be made to court. And when you make such application to court for a remand of a suspect undergoing investigation, you are doing so in anticipation that within a period of not more than 14 days, you'll be able to conclude and charge the person to court formally. But what we find in practice is that this provision is now being used to unnecessarily detain suspects, without the police expeditiously conducting their investigation. After that stage, sometimes they charge persons to court that does not have jurisdiction, particularly lower courts, the magistrate court, the customary court, that have no jurisdiction to try those cases. Those are what are called the holding charges. And holding charges have been said to be unconstitutional. The courts have declared it so in the case of Chike versus Attorney General of the Federation and so on and so forth. So now, the provision of the administration of criminal justice, particularly Section 293, Section 294, up to Section 299, made it abundantly clear the circumstances under which you can report a request for remand. It cannot be more than the first 14 days. If there is reason to extend it another 14 days, after which the court will no longer accept it unless the Attorney General or the Commissioner of Police, show cause why the person should continue to remain in custody. Now, the point I'm making is that the administration of criminal justice system has the police, has the courts, has the DPP or the Office of the Attorney General, and has the prisons as all actors. Now, it is in the process of implementing the provisions of this law that unnecessary delays are caused. If the police do not delay the arraignment of a suspect, the court may delay the arraignment and speedy trial of a suspect when they don't sit, on time, or even when they sit on time, there are days the judge may not be around to sit, and the prisons themselves may not have facilities to transport inmates to court so that their matters can be heard. And under the criminal trials, a suspect cannot be tried in his absence. If he is not in court by reason of the fact that he has not been transferred to court but by the prison authorities, trial cannot go on. And of course, the office of the DPP may sometimes delay in rendering legal advice. All this put together are the challenges facing the criminal justice system that has led to a delay in trial of suspects that have been arraigned before court or that are charged with criminal offenses.
Okay, right, Honorable Samson Usage, let's take it step by step. Let's begin with the police and let's look at the social and economic aspect of that. We all know that wealth has a massive role to play when it comes to issues like this. And now we hear that bail is free, and it is constitutionally supposed to be so. But why has it become an expensive luxury that effectively is used to trap the poor in detention?
Well, talking about the monetization of the bail process by security agencies, it's unfortunate that it has become a norm rather than an exception. I mean, it's obviously a criminal offense to demand for bail, by a security officer in order to grant bail to a suspect. It's a pure criminal offense. It's bribery. There's no other name to call it.
Okay.
But as with most institutions of states in our country, these have become almost institutionalized to a situation where it has even become a policy within the institution. Bail is free, that is true. But is it free in practice? No. The poor will have to pay through their nose in order to secure the bail of their loved ones who are in detention. Now, the question is, how is the system, trying to checkmate officers of the law who are consistently charging money for bail period, for bail applications? It is the challenge. Is the system, purging itself, applying the law in order to ensure that deterrents, are served on those who continue to demand for bail, money for bail? The system is not self-purging. Are other security agencies serving as watchdog on one another? No, because it is a prevalent practice. So it's a serious challenge that requires strong political will to implement and put a stop to. It is not as if the law does not forbid it, but the practitioners of the law, beginning with law enforcement officers, are the ones that are constantly requesting money for bail and even charging money for bail as if it's a fee. So it's a dilemma.
Yeah,
criminal justice system.
Right, Honorable, Samson Usagi, it is quite knowledgeable and it's quite, appreciative of all of this, your profound analysis of how we got to this point. Now that we know all of these rhetorics, we have faced this challenge for decades and nothing seems to be happening. Everybody's involved, from the policing, investigation, and the law system that is failing. Bail is free, everybody knows, but it has been institutionalized. The judicial trial system, from the jury to the DPP's office, with all of these struggles, and our people die and are being kept much more than is expected. How do we get out of all of this quagmire? Political will, or patriotism, or conscience? Where do we start from? Everybody seems to know what is not done properly, but nobody seems to proffer solutions, including those in holding power and holding this country ransom.
For me, political will, patriotism on the part of the police, because you can't pay bribe if you don't consent to give it. It's two-way traffic. So I believe that more effective strategy is to punish those who use it as a means of livelihood, because it has become a means of livelihood for security agencies who are involved in law enforcement. But the citizens must be educated to the level of being able to stand on their rights, particularly in matters where bail is as a matter of right. It is only in capital offenses that bail cannot just be a matter of right. But there are misdemeanors and felonies around that people pay so much through their nose, they sell their property. So I believe that political will on the part of leadership of security institutions and political institutions must enforce this in order to ensure that at least it is minimized. Additionally, the welfare of security agencies, law enforcement agencies, must be improved, at least to reduce the quest for bribes in order to get people released on bail. So it is not going to be a total solution, because we have seen in this country that the more money people earn, the more they are even likely to demand for. But at least we are aware that security agencies do not have sufficient wherewithal by way of earnings in order to take care of themselves. Imagine a situation where a police officer have to be the one to buy his own uniform and buy his own equipment.
But that does not justify that does not justify the wrongdoing.
It definitely will spur them to seek finances in order to meet up their official assignment. So that's my position on it. Political will is a stronger force to deter this and the improvement on the welfare conditions of law enforcement agents.
Okay. Oshora, you may want to give your thoughts on this.
Yes, thank you very much, Right Honorable Samson Usagi, for this. In short, I'm happy.
Thank you.
But in all of this, I think implementation, you've said a lot, and I'm very happy with what you've said. Implementation is key in all of this, because this issue have been lingering for a very long time now, where we've seen people who are poor, but they cannot afford this bill that we're talking about, and that has made many of their wards to die in detention. So, sir, with all due respect, I think implementation to all of these is very key. And I think government should be put on the spotlight, and our judicial process should also be put on the spotlight. And there should be, like you've said, I think the funding and the remuneration packages for police, I think it should be encouraged by the government. I think this is all I have to say for now.
Okay.
So, right, Honorable, apart from what the last contributor just put in, now, people keep talking about the political will, and yet we are rotting. Nobody seems to have everybody has the political will, but the will, the capacity to do good is not always available when Nigerians are prompted to do what is evil. And that is what has brought us to the news. We have had judges who have compromised. We have police officers who have compromised. We have had series of slaps on the face of this country. So where do we start from? Where do we start from? Because we are not going anywhere. Our children are being killed. The system, the structure is rotting. And everybody knows this. What is good for the goose is good for the ganja. Somebody steals 80 billion, pays school fees for a child that is not yet born, yet he gets respite and still working freely. Somebody steals a goat in the Selu market, is impoverished, and the parents are going to they go to the village too. We have had parents who are arrested, kidnapped, and there is no inconclusively, and everybody seems to have their conscience seared and dead, including judges and police, and those are the political corridors of power. So where do we start from? Are you sure that we're going to get out of this place?
Well, I think that is part of the symptom of our lopsided justice system. When I mean lopsided, the fact that people don't seem to get treated equally. It looks like the strict provisions of the administration of criminal justice is applied when high-profile citizens are involved. For example, a judge is not supposed to grant a remand of a suspect with serious crime more than 14 days, and maybe another 14 days in order to conclude. But we see this being used sometimes discriminatorily in some of these jurisdictions. So it's still part of the challenge of the administration of criminal justice system and the our entire society, the way we have chosen to run our system. But the point must be made clear that leadership is involved in every institution, be it the courts, be it the police, be it the prison, at every level. If the strong political will exists to deal with issues decisively, the way they ought to be dealt with in accordance with the law, some of these challenges will be mitigated. And it is not a one-sided affair. The responsibility has to be taken by everybody who has responsibility to enforce the law and enforce it in accordance with the law.
Okay.
So if the courts, for instance, were to take the position that unnecessary delays in prosecution of criminal matters should not be entertained, then prosecutors would sit up in order to bring their witnesses to court and deal with it accordingly. But the situation where, for example, prosecutors continue to give excuses. I mean, with the greatest respect, I am a private legal practitioner now. But not long ago, I was the Attorney General of Edo State, and I understand this from all perspectives. There are usually delays associated with difficulty in prosecuting criminal cases. And that is why the state must put resources at the disposal of state prosecutors when matters are being charged to court to enable them to deal with matters and prosecute them within the time frame allowable by the law.
Okay.
Whether those who are involved are poor people or they are rich people. So that this discrimination cannot continue. And if it doesn't continue, then we can be talking of fairness and justice in the administration of our criminal justice system. This rot is part of the general challenge of the corruption in our system. And until we all agree that we must do the right thing at every point and at every level, then we'll continue to suffer this challenge.
All right, sir, even as we are trying to profess solutions to this challenge that we're looking at today. Let's also look at one aspect that you mentioned, taking the suspects to court where the judge may not be available to hear those cases. Can we also look at a system where we adopt the virtual court hearings? Can this help us? And also, looking at the less privileged ones, let me put it that way, can we scale up these pro bono legal services so that indigent citizens are not left languishing just because they cannot afford representation? Let's end on that.
Yeah, you raised a number of issues. We start with the issue of pro bono services for the less privileged, the issue of court not sitting,
virtual hearings,
and virtual hearing. Yes, for example, in Edo State, where I now practice mostly, the criminal courts are doing quite well because when they cannot sit, they also make use of virtual court hearings. But virtual court hearings are usually done in other matters except civil cases. It's usually difficult to do virtual hearing in a criminal proceedings. That is the challenge, because the suspect will have to be present in court, and the judge cannot be in Abuja, and then the suspect it will be very clumsy. Virtual hearings are used, but seldomly in criminal matters. Now, when I mean courts are not sitting, what I mean is that court may not sit on account of one or two official reasons, but the bulk of the challenge of the delays is usually from the prosecution and the police. Because when you charge a suspect to court, the prosecution and the police ought to bring their witnesses to court in order to be able to testify and have the case tried. But what we find in most cases is that these witnesses are not immediately available or procurable by the prosecution and even the police. The police officers that are supposed to also be witnesses and FPOs may have been transferred from jurisdiction, and the cost of securing their attendance may be very difficult unless the suspect or an interested party has to pay. These are some of the challenges, and sometimes when courts are on holidays or they are on vacation, it leads to delay. Because normally when you have special court sections or vacation judges, they may not hear cases that are already pending. That is one. Then on pro bono cases,
yes,
I can say, for instance, that I'm aware that there is the Administration of Criminal Justice Committee headed by the Chief Judge in the Edo State. The Attorney General is a member of that committee. I'm aware that that committee, in the last 1 year, for example, in Edo State, had worked very closely with the Administration of Criminal Justice at the federal level to institute what you call police duty solicitors. Now, these police duty solicitors are expected to provide lawyers for the indigent suspects from the police station up to the point they are being tried in court. And apart from that, there are so many NGOs too that lawyers belong to. For example, the Legal Aid is just one of them. There are others that lawyers belong to. Judges are made aware of these organizations. And whenever a criminal suspect is before a court without a lawyer, the judge will normally call on any of the lawyers in court to take these cases up. I can assure you that so many cases are being done pro bono. You know, yours truly, I can say that 90% of the cases I do today are on pro bono basis, from the High Court to the Supreme Court. And I'm aware of so many lawyers that are doing so. But the challenge remains in mostly the logistics arrangement in bringing witnesses to court, and even bringing suspects to court themselves. That is the main challenge. Thank you.
All right. Thank you very much, Right Honorable Samson Raphael Sagi, PhD, for your time. Well said. Now we know where to shift our focus. Let them get to court early, and the judges will be ready to try them, and thereby decongest our prisons. And because it has a lot it does to the psychology and even the economy, feeding inmates. It does a lot to the economy too. Thank you for joining us this morning. Enjoy the rest of your day. like to hear from Shore Amige. Your concluding thoughts.
I think implementation, like what I said before, it's all that matters in this particular problem, because people are dying, especially those who cannot afford the largest have to do with a base system. People are suffering. People are selling their properties to, to bail their family members and their friends who were kept in prison. If you look at the way Nigeria is right now, everything is just in opposite direction, and it's painful. Police, we have to arrest first before investigation. I think government should implement all of these things that have been said, so that there will be a quality administration of law in Nigeria.
All right, thank you very much for your time.
Thank you very much.
We appreciate you. And Kayode,
Well, I think it's a conscience thing. We are all under the same umbrella. It's our country, the Federal Republic of Nigeria. Let's be conscientized. Let's be more patriotic. Let's be more humane about our people. It has to do with, when you talk about political will or willpower, everybody has this will to do good. If the police does their own without, thinking of, what to get first, and the judiciary also holds its ground, we have lesser of all of these, conjunction and complication where families are allowed to suffer. We lose our people because all of this means we're driven into whatever they find themselves.
Yes.
Because of deprivations, because of, not finding their their food.
Yeah, thank you very much. And that's how we call it a day on the show. On behalf of the entire production team, Kayode Albede, Daisy Egosa, and everyone out there, thank you for joining us this morning. I am Gloria Osuma, asking you to have a productive day. Good morning.